Jefferson County Court at Law number 2 is now in session. The court is in session with its jail review docket. First case is cause number 26CCCR 0512. Case is styled the state of Texas versus Michael Shane Messer. Mr. Messer, is that your full name?
Yes, sir.
Mr. Messer, would you please raise your right hand? Mr. Messer, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Messer, you may put your hand down. How are you doing, Mr. Messer?
I'm doing fine, sir. How are you?
I'm doing fine. Thanks for asking. Mr. Messer, you're representing your case by your attorney, John Macy. Mr. Macy, how are you doing?
I'm fine, Your Honor. Thanks for that.
And Mr. Macy, do you waive a record in Mr. Messer's case?
Yes, Your Honor.
Mr. Messer, the state is represented in this case by attorney Cornelius Williams. Attorney Williams, how are you doing?
Doing very well, Your Honor. And how are you and your lovely staff?
We're doing fine. Thanks for asking. Now, Mr. Messer, I have before me on my computer a document that was filed by the Jefferson County District Attorney's Office. This document is titled Information. In this information, it alleges that you, Michael Shane Messer, on or about January 14th of 2026, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal trespass. Mr. Messer, do you understand what you have been charged with?
Yes, sir.
To this charge, Mr. Messer, how do you plead guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges?
Sir.
Mr. Messer, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials, MM, on a line next to a box that check nolo contendere, which means no contest. Did you place your initials on this
Yes, sir.
document? On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. And do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes,
Defendant?
sir.
Mr. Messer, before you signed and initialed these documents that I'm showing you, did your attorney go over these documents with you?
Yes, sir.
Did you ever understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Messer, are you a citizen of the United States?
Yes, sir, I am.
State will tender State's Exhibit number 1, Your Honor.
No objection.
No objection. State's Exhibit number 1 will be admitted. And Mr. Macy, you have advised and counseled Mr. Messer. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Messer, your attorney, Mr. Macy, has advised and counseled you. Are you satisfied with his representation?
Yes, sir, I am.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Messer, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement is the following essential terms are, Judge, there will be 20 days Jefferson County Jail, time served, time actually served, and all court costs will be taxed and retired. And in consideration of the plea, the state will dispose of 26 CCCR 0513, dismissed pursuant to 12.45 of the Texas Penal Code. Is that correct, Mr. Lynch?
Yes. This is the agreement, Judge.
Okay. Mr. Messer, the state is offering that you serve 20 days in Jefferson County Jail, but you would not have to serve any more time in the Jefferson County Jail on this case because you've already served 20 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Now, the state will be dismissing cause number 26 CCCR 0513 pursuant to the Texas Penal Code Article 1245 dismissal. Now, Mr. Messer, do you understand the state's offer?
Yes, sir.
And do you think that the state's offer in your case is fair and just?
Yes, sir. I do.
And do you accept the state's offer?
Yes, sir. I do.
Okay, Mr. Messer, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Messer, if you do not have anything else holding you in jail, you should be getting out of jail today. Okay? Now, Mr. Messer, you're gonna stand next to the bailiff, follow her directions. Once you're finished following her directions, you'll follow the bailiff and you have a blessed day.
Yes, sir. Thank you very
Okay.
much.
All right.
Don't forget to see.
Ma'am,
You don't have to do a dismissal. You do this. You don't have to do a
Oh.
you
dismissal.
gotta get the fingerprint.
Yeah, she has to let her know, Miss, Mosby.
Excuse me.
Yeah, she may be excused.
Thank you.
He has to be printed on this too.
He was asking, did he have any more charges? I couldn't answer the question. I don't know.
I just, when I came to jail, they told me I just got 2 trespasses.
Do you know? He needs to print out. Okay, she'll check.
Didn't have any holes. I was just asking.
Okay, she'll check. Hold on a minute. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 24 CCCR 1586 and cause number 24 CCCR 1846. Both cases are styled the state of Texas versus Cindy James Darcy. Mr. Darcy, is that your full name? Mr. Darcy, would you please raise your right hand? Mr. Darcy, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Darcy, you may put your hand down. How are you doing, Mr. Darcy? I'm doing fine. Thanks for asking. And Mr. Darcy, you're represented in your cases by your attorney Jack Lawrence. Mr. Lawrence, how are you doing?
Just fine, Your Honor.
And Mr. Lawrence, do you waive a record in Mr. Darcy's cases?
Yes.
Okay. Mr. Darcy, I have before me on my computer in cause number 24 CCCR 1586, a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Sydney Darcy, on or about April 29th of 2024, while you were in Jefferson County, Texas, that you committed to Class A misdemeanor offense of resisting search. Mr. Darcy, do you understand what you have been charged with?
Yes, sir.
To this charge, Mr. Darcy, how do you plead? Guilty, not guilty, or no contest? Now, you pleaded no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Darcy, I also have before me on my computer tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials on a line next to a box that's checked no contendere, which means no contest. The initials are CD. Did you place your initials on this document? On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Next box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Sir.
Mr. Darcy, before you signed and initialed all of these documents that I am showing you, did your attorney, Mr. Lawrence, go over these documents with you?
Sir.
Did you understand everything that Mr. Lawrence went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Darcy, are you a citizen of the United States?
Yes, sir.
State, would you like to offer State's Exhibit Number 1 into evidence?
So tendered, Your Honor.
Any objections, Mr. Lawrence? No objections. State's Exhibit Number 1 will be admitted. Mr. Lawrence, you have advised and counseled Mr. Darcy. Is there any evidence that he is currently mentally incompetent to stand trial?
None, Your Honor.
And Mr. Darcy, your attorney, Mr. Lawrence, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay, Mr. Darcy, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
It would be 80 days in the Jefferson County Jail, time served, time actually served, and all court costs should be taxed and retired. And further consideration of the plea, the state will dismiss 24 CCCR 1846.
Okay, Mr. Darcy, The state is offering that you serve 80 days in the Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail because you've already served 80 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you would not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Darcy, and the state will be dismissing cause number 24 CCCR 1846. Mr. Darcy, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
Do you accept the state's offer?
Yes, sir, I do.
Mr. Darcy, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Darcy, if you do not have anything else holding you in jail, you should be getting out of jail today. Now, Mr. Darcy, you're gonna stand next to the bailiff, follow her direction. Once you finish following her direction, you're free to follow the bailiff and you have a blessed day. And Mr. Lawrence, this will conclude your cases. You're free to go and you have a blessed day.
Thank you, Your Honor.
You're welcome. Jefferson County Court at Law number 2 is back in session. The court is in session in 2 cases. They are cause numbers 24 CCCR 1318 and cause number 25 CCCR 1294. Both cases are styled the state of Texas versus Barry Shaw III. We have Mr. Barry Shaw present in court with his attorney, Attorney Todd LeBlanc. State is present with Assistant Criminal District Attorneys, Attorney Cornelius Williams. The court has before the motion to revoke probation in both cases on February 19th of 2026. Mr. Shaw pled true to allegations 3 and 4 in cause number 24 CCCR 1318. And on the same date, February 19, 2026, Mr. Shaw pled true to allegations 2, 3, 4, and 5 in cause number 25 CCCR 1294. The court reset this case for a pre-sentence investigation report that it has received. Mr. Williams, having received a copy of the pre-sentence investigation report.
The state has, Your Honor, and I see no addition, deletions, or modifications
Okay,
from the state's perspective.
and Mr. LeBlanc, have you received a copy of the pre-sentence investigation report?
I have, Your Honor.
And do you have any objection to the finding, conclusion, recommendations?
I'm sorry, did you say?
Or do you have any additions or deletions that need to be made in the pre-sentence investigation report?
No, Your Honor.
Okay, you may be seated. Now, the court has set this case for a punishment hearing in these 2 cases. State, are you ready? And defense, are you ready?
We are, Your Honor.
Okay, and Mr. Williams, you like to proceed?
Thank you, Your Honor.
You
The
are,
state will proceed by way of aggravation at this time, Your Honor. I realize that the court has had an opportunity to review the pre-sentence report. Several things are disturbing throughout, Your Honor. It is clear that he did a de minimis amount of his obligation, but what is more concerning, Your Honor, for the state is that he failed to enroll in to complete, the batteries intervention program, Your Honor, and accompanying counsel. Was also very troubling, Your Honor, as he pointed out to the court previously in hearings, that he had like a child that is on the way, Your Honor. But what is troubling, and I turn the court's attention to page 2 of the pre-sentence report, sir, is that this 28-year-old young man has 6 children, of which, Judge, he does not know the name of 3. Judge, I point that out, given that you have before you an assault family violence case to where you assaulted one of like the mothers of these children, Judge, that's unacceptable. The state will recommend 180 days, Judge, on number 24 CCCR 1318, and will recommend 90 days on the 25 CCCR 1294, the assault family. And the only consideration which the state will do, Your Honor, opposed to asking for those who want consecutive as they can, we ask that the 180 days between the 2 matters run concurrent with the 180 days, Judge.
okay. Mr. LeBlanc?
Yes, Your Honor. Well, obviously, we want people to be successful on probation. Although I don't see that, think it's egregious if you don't know your children's names, but I don't know that that rises to the level of need to be incarcerated. If you look at this PSI report, Judge, I think it's misleading in the sense that there are a lot of these, technically, I would think the court cannot consider in its criminal history. A lot of them were dismissed.
Mm.
And on the first page and on the second page, there's four of them. On the second page, there's four of them that were refused or dismissed. And the only one on the second page is, page 3, I'm sorry, Judge, is the present case. At the top, rest were refused or dismissed. So, Judge, I would ask the court to not take those into consideration in disposing of this case. He wants to complete probation. I think it's clear in the report. I think that he just spent, how long? He just spent a month and a half in jail and,
I had a dog.
yeah, hold on.
Oh,
And that was enough of an eye opener for him. He didn't have to, we could have come in here for sentencing, but I think he bonded out at the beginning of this month. And since then, he's been working, he's been taking care of his business. What the court does have is in 2014, he did successfully complete a probation. That's a positive. It says community supervision expired now. Don't know why it expired. Now, I know in this case, the motion to revoke was filed pretty much at the term of towards the end of his probationary term. And granted, he hasn't, his adjustment to probation has shown that he still has some things that he needs to do. I do think that this most recent occurrence was an eye opener for him. As he stated in there, he wants to do whatever it takes to not go to jail. And he does have a newborn or about to be born.
Yes, sir.
Okay. And he would like to be a part of that child's life and be out there and continue working. He did get a job like he said he had when he was in custody. And so, Judge, we're asking the court to continue him on probation, give him a chance to complete this. I know that the probation department says they don't want him on probation, but you know, that's what we signed up for, and he's willing to complete it, and he does not want to go to jail, Judge. He has something he wants to tell the court as well.
Okay,
Yes, sir. I can.
hold on, let me swear you in. Okay. Okay, you swear to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Okay, you may put your hand down. You can sit down.
Yes, sir. I came here to take care of my business. I actually had to go to work today, but I took off to come handle my business with y'all to do what I needed to do.
Okay, now where are you working?
I work for Patty's Mobile Detail. I detail lawyers, doctors, courthouses. We go everywhere.
Okay, now, now, when did you get out of jail?
Or
About 2 weeks ago. About 2 weeks ago? Yeah, it had to be about 2 weeks ago. And so what have you been doing in the interim?
I've been out of jail. I went to work again today. I took off today because I told them that I had to go to court. And he took me out of school today because I told him I had to be at court for 8:30.
Okay, okay, now, you stated that, well, I'm just looking at the PSI. What are your living arrangements? And I mean, do you live alone? Do you live with someone? Like, do you have a relative or somebody that you're living with?
Yes, sir.
Oh, so you're living with your mother. Okay. And now, in reference to So since you've been out of jail, the only thing you've been doing is you just been basically working, that's what you're saying?
Yes. If I do what I need to do, keep me successful, I'm going to jail.
Okay, now. You realize that the court has not, hadn't revoked your probation.
Yes, sir.
So which means that you're still on probation.
Yes, sir.
And I'm looking here at have you talked to anybody with the probation department since besides the PSI officer?
Yes, sir, I called Mr. Gillian to let him know that I got out of jail. And I left a message on the voicemail. He never gave me a call back, but I did leave him a message to let him know what I had going on.
Okay,
And just, of course, the court knows that I think you can extend the probation. I think it's expired. Set to expire, if not. Pretty close. I mean, I think that's an option the court has to extend it.
I mean, the court has the option to extend probation. According to law. Anytime within a year of even after expiration. Okay, I mean, I understand that, but. Now. Now I'm looking at. Okay, I'm looking at this pre-sentence investigation report. It says the defendant through his own action has shown that he has no intention of following his court orders. And it is the belief of this officer that probation on both cases should be revoked. So going back to the allegations that you pled to in cause number 25 CCCR 1294, it shows that you failed to report in November of 2025, December 2025, and January 2026. It also showed that you failed to pay court assessed fees as ordered by the court. And as of January 28th of 2026, you were $655 behind or in arrears. It also showed that you failed to perform any of the community service hours that you were required to perform. And this final allegation that you pled true showed that you failed to successfully complete battering intervention and prevention program, commonly referred to as BIP, or an approved anger management intervention program, and pay all associated costs as ordered by the court in violation of the additional condition 8 of your probation order. And then in the other motion, there were two allegations. One, allegation number 3, that you pled true, state that you failed to pay court assessed fees as ordered by the court, and as of October 2nd of 2025, you was $1,279 in arrears. And the second allegation basically said that you failed to perform the community service ordered by the court in violation of condition 17 of your probation order. So the question that I have, I guess, maybe to your attorney, what did he do while he was on probation? Since we know what he didn't do, what did he do while he was on probation?
I'm reading that I don't know if the court identified that he's done 10 hours of the 60.
Where was that? That's in the,
Under the third paragraph in adjustment probation.
on page. What page is
I'm
that?
sorry, the first page.
Is that in the PSI or in the,
Yes, in the PSI, that's down there at the adjustment to probation, the third paragraph,
let's see, yeah, 10 complete, okay, yeah, abscond, okay.
and he's paid $247. And is currently in arrears of.
1,600, yeah. His total hours that he was required.
And also, Judge, he's abstained from the use of illegal substances during his probation term. That's what it says there, and that, I think that's pretty important in looking at all probationers as a totality. I mean,
So you're saying that he abstained from the use of illegal substance throughout his probationary term? He completed 10 hours and he paid $247. Is that correct? So that was,
Your Honor, one thing,
yes.
when he talks about the probation, I kind of take issue with the probation officer saying that it's been through his own actions that's shown that he has no intention of following court's orders. I think every bit of his actions today shows that he's willing to follow it. He's shown it, he's bonded out, he's shown up to court, he's working. He hasn't committed any new offenses. He's drug and alcohol free. I think that maybe his past actions could be deduced, obviously, that he had no intention he had little intention of completing it. I think that possibly being in jail this time, he might have wisened up. And I know that he's stated several times he does not want to be there and he's willing to do what it takes. Those are just words, of course, no, but sometimes it takes what it takes, and I think he can be successful at it. I don't think he wants to be in this courtroom. So that alone is enough motivation.
Hold on a minute.
If I may briefly note.
Yes,
I would be remiss if I didn't point out that he just referenced to the court judge that he's staying with his mother, Judge, but yet he told the probation officer that he's staying with, reported to be residing with his cousin in Beaumont, Texas, upon release from jail. There's no name of the person, the cousin who he's living with. So you have before you now two competing. We don't know if he stayed with his mom. He told him that he stayed with the cousin. But how did he bond out of jail, Judge, while on probation? There's no mention from his aggravated arguments and mitigation. And his arguments and mitigation, not once did he mention providing any type of care or funding, Judge, for the three kids' names that he does know. So he would rather place his money elsewhere because it's clearly it's not going to the probation department, but he thinks enough of himself to represent to this court two different places for where he's living, and not once mention those children or if I've been working or providing for those children, Judge. His actions, I think, speak for themselves, Judge.
okay, Mr. LeBlanc, you have a response?
No, Your Honor.
Okay. Just weighing the fact, I know he said that he had been out of jail 2 weeks. Okay. Now, how often do you get paid?
Get paid almost every day.
So it's like a cash type deal based on like number of cars that you might wash or something.
Dues, how we get paid. We on card, we get paid on Wednesdays, Fridays, Saturdays, and Sundays.
Okay. Now I was just looking at the let's see, hold on a minute. I was looking at the number of community service hours. Oh, yeah. Okay, that's easy. So I'm just looking at the number, you said, okay, you did at least, well, 10 hours of community service, right? Now, total you was required when we add both cases together. Yeah, you did 10 hours on the case that you were required to do 60 hours on. And you didn't do any on the case that you were required to do 40 on. Okay? So we say 1640 is 100, you did 10 hours, you did about 10% of your community service. And in reference to your payments, you did about 15% of the payments in the first case. It appears to me like, I'm just looking at, in the first case, cause number 24 CCCR 1318, which you was placed on probation February 12th of 2025. You had 60 hours of community service. In that case, you did 10. You was required to pay fine, fees, and costs in that case. You paid 247 hours, and you were in arrears 1,636. And in the second case, you were required to perform 40 hours of community service. You did not perform any. You were required to pay fine, fees, and costs in that case. You did not pay anything in that case. You were required to apparently it looked like if we just use this the first and the second case, the first case you made small payments, you did a minimum amount of community service. You get a new case, and I think that's right, there was an issue with regard to this you get the second case and you didn't do anything on that. Okay, so why would the court be inclined to believe that you're gonna do your probation? Yeah, you didn't do nothing on the second case. And I'm just looking at the records and looking at the motion, don't look like you did anything on the second case. You started doing something on the first case, and then on the second case, when you get the assault, family violence case, you didn't do anything. Didn't do nothing at all. And in fact, I think both cases he absconded. It says, I guess after you got that other case, they say you absconded, which means you just left and didn't do anything. Okay, but now you've been out 2 weeks, you've been in jail for a month, right? At least you've been in county jail for a month. And now you see out 2 weeks, you say that you want to change. What
Willing to go out and pay and do whatever I need to do that I have told us getting when I left to abortionist. When I was paying, but now I have enough to pay him whatever he want me to pay him.
well, you weren't working then?
I was working, did be, but I wasn't working as much as I was working now to pay him like 190 a month. So the little money that I did have, that's why I was putting towards that to make a payment. And when I was making the payment, so he didn't have a problem with paying what I was paying.
Okay,
I was
okay.
paying something.
Okay, so let me look at this here again. So why didn't you perform the community service? You don't have to pay to perform community service.
Transportation was down. I had to start riding the bus. I got me a bus pass to get back and forth downtown.
Okay, but I mean, you could get a they could have had you do community service at the courthouse. And you could almost get anywhere around Beaumont in a few minutes, even if you had to walk.
I was going downtown by SOP, going.
What's SOP?
It's like clean up the restroom and stuff like where the homeless people be.
Is that on McFadden?
Yes, sir.
Say,
Other place. too.
oh, some
Yes,
other
okay.
place. Okay, at some other place. Okay,
I bad.
okay. So why you just stopped going there? You said you started going, but I mean, why didn't you continue?
Every time, so like, can I go in the afternoon? 'Cause they got evening and they got noon. I was
Why
in
couldn't you go?
School.
I don't understand that. You said they wanted you to come in the afternoon,
it
but you're
was
saying it
full,
was, what you mean it was full?
two people, service.
That don't make sense. If they wanted you to come in the afternoon, apparently they'll find something for you to do, I would think. I mean, that's the assumption so you went there before and they turned you down until they didn't have work or something? Yeah, but, and so you just stopped going. Well, you just gotta keep going. I mean,
I was trying to find some work to do community service, which I thought I was gonna be able to do it at the probation field like everybody else be doing, where I guess they get on the van and they go work and stuff like that.
yeah, okay. Now, what about anger management? Why didn't you, attend and complete the anger management? And the batters intervention and prevention program, BIP?
I was going through a little phase of
Oh,
it was.
okay. Okay, okay. You know, we all go through we all go through things. That's just,
Hard getting right
that's life. Yeah, but I mean,
time doing. People to bring me to, yeah, place and drop me off or get whatever I need to do.
but now, so you didn't have that then, but now you have it. And who are these people that is gonna be responsible for bringing you to and from?
30.
Oh, okay. Yeah. I'm looking at your criminal history, and as your attorney pointed out, their court is not considering, there's like one, two, three, four cases that was dismissed, and one, two, three, four cases that were refused. Okay, so apparently they just have it in your criminal history, but it wasn't, um, you weren't convicted of those. Okay,
Yes, sir.
but you do have, I see one case as your attorney pointed out, you completed probation on one in 2016. And also in that same year, same month that the probation was completed, you received 10 days in jail for a case. And 5 years later, in 2021, you also received 10 days in jail for a case. And then you was placed on probation for these two cases. One case you have 180 days, other case you have 90 days. Let's see, hold on a minute. The pre-SI officer also pointed out, which is, I guess mitigating the fact that, you stop using illegal drugs throughout the probationary period.
Yes, sir.
Okay, that's a good thing. Of course, you employed now, that's good. Okay, this is what, okay, this is what the court is gonna do. At this point, at this time, the court is gonna hold its, ruling in abeyance for 30 days. And, within that 30 days, we're gonna reset this case and we're gonna see how you, do on this probation. Okay? You have community service, now you say you're working, so you should have to be able to make payments. Okay, but I mean, so we're gonna hold this ruling in abeyance, which means that the court can come back in 30 days and revoke your probation if the court sees fit. Okay? And so we're gonna hold the ruling in abeyance for 30 days. Okay? And, we probably need to put him on a day that we have, MTRP, on our MTRP docket. Okay? Okay, so that's what we're gonna do.
And I presume on that date that we get, Judge, we'll come back to see what progress he's made.
Right,
So he needs to do everything he can within the next 30
at
days.
30 days. Okay? Okay. All right, for the being recess.
I know. y'all-
Okay, Jefferson County Court at Law number 2 is in session. Court is in session and calls number 26CCCR 0520. Case is styled the state of Texas versus Derek W. Hayward. Mr. Hayward, is that your full name?
Yes, sir.
Mr. Hayward, would you please raise your right hand? Mr. Hayward, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Hayward, you may put your hand down. How are you doing, Mr. Hayward?
Fine. And yourself?
I'm doing fine. Thanks for asking. Mr. Hayward, you are represented in your case by your attorney, Attorney Christy Carlton. And Ms. Carlton, how are you doing?
Doing well, Your Honor.
That's good. Ms. Carlton, and state is represented in this case by Attorney Cornelius Williams. And again, Mr. Williams, how are you doing?
Very well, thank you, Your Honor.
And Ms. Carlton, I have before me a motion for competency evaluation. You filed this motion pursuant to Article 46B.004 of the Texas Code of Criminal Procedure. The court is going to conduct a hearing to see whether or not that there is any evidence from any source that would support a finding that the defendant may be incompetent to stand trial. So the court is going to conduct an informal inquiry, and the court will consider the factors that are listed in Article 46B.024 of the Texas Code of Criminal Procedure. And pursuant to Article 1.24 of the Texas Code of Criminal Procedure, all trials and proceedings shall be public. However, pursuant to the case of Liddy versus State, 365 Southwest 3rd, 321, the right to a public trial is not absolute and may be outweighed by other competing interests, such as the interest of security, to ensure that the defendant receives a fair trial and to prevent the disclosure of non-public information. Ms. Carlton, are you requesting that this portion of the hearing be closed to the public to prevent the hearing of non-public information?
I am, Your Honor.
Okay. The court finds that the parties seeking the closure of this hearing have advanced an overriding interest that is likely to be prejudiced to a client. The closure is no broader than necessary to protect the client's interest to prevent the disclosure of non-public information. The trial court have considered other reasonable alternatives to the closing to support this closure. And the court make these findings that's adequate for the closure. So at this time, this hearing will be closed to the general public.